Marshall. I think it is we're at the witching hour, so I think we can get going. All set? Okay. All right. I will call this meeting of the Property Insurance Task Force to order. Formally, it says I call the order of the January 21st, 2026 meeting of the Homeowners and Commercial Property Insurance Task Force. A quorum is present. And who are the members joining remotely, Austin?
The members joining remotely are Jacqueline Domenici Bruno, Senator Dames, Tim Johnson, Jessica Sheminsky, and I believe that's it for now.
That's it for now. Okay. So the next order of business is the approval of the previous meeting minutes. Does everyone had a chance? Adam, did you have a comment or?
Yeah, Mr. Chair, I do have one amendment to the minutes. Jean had joined us last week via Zoom, but I don't believe that's reflected in the minutes as presented here.
Okay, Mr. Chairman will make note of that. With that amendment, if there are no other corrections to be made, would somebody like to move the approval?
Yeah, I'll make a motion to, yep, I'll make a motion to approve the minutes, Mr. Chair.
Okay, moved. Second. All those in favor say aye.
Aye.
Opposed?
Aye.
Okay, we have minutes. So the remaining item on the is our recommendations discussion, and we had votes on three of them last meeting. The first item, the third item, and the fourth item. I think what we'll do is we'll go through these in order. So we want to go to the second item here. The first one. So start there. Okay. So and then Ms. Hatt is going to kind of you're going to walk us through these as with the summaries and everything. And so I'll hand it off to you.
Thank you, Mr. Chair. Good afternoon, everyone. I'm Katie Hatt from Management Analysis and Development. We are the state's consulting practice, and I'm here to support Elsa Fee and the chair with task force administration. You'll see in your packet, there is a slide deck for members and members of the public joining us remotely. These slides will be shown on the screen. So for today, the recommendations up for discussion roughly fall into three different buckets. So the first bucket are three recommendations, which you saw last time, and which for two of them, there were very minimal changes. So we'll walk through those pretty quickly. Then the remaining recommendations, there are two that you discussed the topics of last time, but there wasn't specific language to look at or to gauge your support for. So we'll look over those. And then there are two new recommendations on topics that have been in the task force discussion and at previous meetings that the chair requested come forward today for consideration. And for those second two buckets, we will do the fist to 5 exercise again to gauge where your current level of support for the various recommendations are. So here are the first three. Again, just to refresh, we won't do fist to 5s on these. The first one relating to the FAIR plan. As you can see on the notes, there were no proposed changes to the language. Mr. Chair, I believe a task member would like to be recognized.
Yes, I'm sorry,
Turn the
Jean.
volume up here.
Mr. Chair, I did submit some suggestions on that first recommendation to Mr. Chairman and also in the meeting.
Okay.
So I had suggested that we define what we're talking about by insurance products in that section to be specific to commercial property, that we address the funding of that study and that would come from the current budget
As part of the study.
as part of the study.
Yeah.
So I didn't see those, just wanted to make sure those were being addressed.
Ms. Hatt?
Okay.
Mhm.
Very good.
I distinctly remember that discussion.
Okay.
Hmm.
And then just one other note for this recommendation, the assessment is that this would not require separate legislative language to implement pending the updates just shared.
I think that was the consensus.
Okay. So we will jump to recommendation number 3. This reflects in red line, the word fully has been deleted from this, consistent with discussion at the task force meeting on January 7th. And legislative language drafting is in process or in progress.
Yeah, and then Mr. Brickwood, do you have any update on where we stand on the legislative language? I know I've seen evidence that, no, nothing to report.
No, Mr. Chair, I think the last update I had was
Can't talk right
the
now.
update that we got at the same time from Laurie announced research that she could just, it would be like a rider language, so she could get that drafted, but I've not seen anything back from her on that yet.
She hasn't drafted it yet. Okay, yeah, as we get closer to the beginning of the session, I think we're all of us who are having asked for legislation to be drafted are finding that the queue is beginning to get clogged. Okay.
Okay, and then the last in this first set, recommendation number 4. I believe a task force member, Ms. Midgley perhaps, had requested clarification that this applies to new construction, which again is reflected in red line on the slide here as shown. And this is another one where the legislative language drafting is in.
Yeah, so same story here. So Anna Cholene writes most of the language for DLI bills, and she's been on vacation and just got back yesterday. In the interim, but while she was away, I did meet with Greg Metz and his team at DLI about the broad outlines of what we want here. And I'm going to be incommunicado for about almost the next 2 weeks, but I have deputized Anna and Greg to develop a draft in my absence. I trust them both to bring back to us in time for the next meeting. And I'll have them also, as soon as they have something, I'll have them ask them to circulate it among us immediately, not wait for me to get back. Okay.
Oops, okay, so next. Recommendation, okay, so we're gonna go back to the Vista 5 pulse checks that we used the last time to gauge consensus at the current time. So this is
I have
not a formal vote.
One thing on that is I also connected them with Michael Newman from IBHS as well, so that they have him as a resource also. Thought that would be good. Okay, sorry.
No worries, great. Okay, so again, this isn't a final vote. We won't be reporting back individual member results, but to understand where there's support, where there is concern right now, and where there is concern, if any changes might move people towards support. So again, here is our scale in your printed packet, members, or if you're using an electronic copy. Dog-ear this if you want to go back through the reviews to just remember the labels here. But again, generally 0, 1, 2 are you do not support it to varying degrees. And then 3, 4, and 5 are you can live with it, generally support it, would be inclined to vote in favor next time, up to you really strongly support it. Any questions about that before we get started?
Comment. So again, I think Mr. Axbig is working with the Department of the person who does drafting for the Department of Revenue, Sean. So do you want to just give us a brief summary of where you are with this one?
Are we still talking about the building codes process, Mr. Chair?
Wait a minute,
Have
am I
we
in the
moved
wrong
on?
one? No, creation of catastrophic and mitigation savings accounts.
Oh,
Yes,
sorry. I didn't know we moved
So,
on to number 5.
it's number 5, yes.
Yeah, so I met with Mr. Sean Williams, the nonpartisan staff who works for the House Tax Committee last week and walked through the model language that had been distributed to the task force. He did flag some concerns or some things that maybe the legislature needs to take into consideration when crafting this bill. Mr. Chair, would you like me to kind of do a walkthrough here of the
Quick
bill?
walkthrough. Anybody, you lucked out. He's really good.
Yeah, seems really good, but again, with the incipient session, I think he's pretty overloaded
Yeah,
as
yeah.
well. So with the model language in front of us here, section 1 is the title, self-explanatory. 2, the purpose as well is fairly self-explanatory. Section 3 deals with the language around the creation of the account. The maximums, I believe, are addressed later, but it does lay out a process for folks overfill those accounts beyond the legislative authority, or excuse me, beyond the legislative maximum there. So there's some process there. Section 4 deals with the distributions from said account. You know, again, some of the process around how that's covered. One thing to flag there, I would say, and this is something that Sean had brought up, is how do we want to deal with who enforces what's actually a qualified expense under this program? Where would that authority lay? And so I think that's something that, you know, the legislature needs to be thoughtful in considering. Section 5 lays out some rulemaking, grants agencies some authority to create some rules around this program. Section 6, definitions, again, fairly self-explanatory. But as drafted, or as this model language is, it does anticipate potentially 2 different programs or 2 different accounts. One for catastrophic events and the other one would be for building resilient. So there'd be a tax advantage if you wanted to add more resilient materials to your house, or, you know, you could create a standalone account for those efforts as well. Again, I think that's something for the legislature to consider, but I think it's a good idea, and I think most of the folks on the task force would agree. So I believe that's a fairly concise, but you know, walkthrough of what the model language in front of us does.
Any questions or comments related to this?
One thing to note, Mr. Chair, I would just say, I believe the amount anticipated is just kind of a fill in the blank, is $15,000. There's also a tie to a deductible there as well that's in the language. But just, again, another consideration for the legislature to have when they're crafting based on this conceptual language here.
Okay.
If no clarifying questions, can members in person just hold up your hand with a number of fingers to correspond to your rating? And for our members who are online, if you can open up the chat, meeting chat, and drop your number in the chat.
This is Jessica Shiminski. The chat is disabled for me on Zoom right now.
Okay. Are members comfortable if I just do a roll call of the online members?
Oh, it just got activated.
Oh, great. Okay. And tech support wasn't even at the desk. That was magic. Great.
Excuse me, Mr. Chair, I personally wouldn't mind knowing, you know, who is, because in the room we get to see everybody, but online we don't have any idea. So I wouldn't mind a roll call.
Well, the chat's working again, so they'll just drop it in the chat.
Oh, okay.
Okay.
I think, sorry, Katie, I think what Carrie meant was that, like, those of us on Zoom get to see the numbers. We put each other in the chat, but the people in the
I see.
room aside from you aren't on Zoom, so they don't get to see the numbers we've dropped in the chat. I dropped a 4.
Okay.
So did everyone else on Zoom, actually.
Okay. Okay. 4 and 5. Okay. 5. Okay. And 3. Okay. 4. 3 and 4. Okay. Okay. Okay, and all the others are at 4 online. So I am seeing and Senator Dames.
4.
I'm sorry, did you say 4?
Yes.
Okay, thank you. Okay, so no low ratings of 0, 1, or 2, 2 ratings of 3, 9 of 4, and 2 of 5. Chair, any discussion, further discussion on that item?
No. Comments, questions? No?
Okay. On to the next recommendation. Whoops, sorry. Okay, draft recommendation number 6. As worded here, the task force recommends passage of Senate File 2929, the Consumers and Crisis Protection Act.
Mr. Brickwitty?
Mr. Chairman, I just a clarification on on the recommendation here before we get into fist to five, is the idea here that we would pass the bill as introduced? Or is it that like the task force recommends that this bill, get a hearing and sort of start moving through the process?
Well, I think it's an indication of support for the substance of the bill. Bills, you've been around here long enough to know that no bill ever emerges unscathed from the committee process, but
Well, Mr. Chair,
rarely.
a point well taken. I do think that might make a difference, because I think, for example, the department has not been asked for a fiscal note on the proposal as to date. But I would anticipate, just reading the bill as introduced, that there likely would be a fiscal cost for our agency for a portion of the bill that's somewhat separate from sort of the main substance of it. So there may be some mechanical things, and maybe that's just important for me to be able to take back to my colleagues at the department. But I think a more precise recommendation from the task force might garner more support.
Sure. So this is an introduced bill. This is Senator Seeberger's bill, and have you requested a fiscal note? Why don't you explain what this does?
Thank you, Mr. Chair. This bill, the Consumers in Crisis Protection Act, provides some parameters and framework around third-party litigation funding, and requires essentially disclosure, so all parties are aware of what's going on. There's no specific prohibition involved. The idea is to set out some regulations in an area that is not currently regulated. We talked a little bit about it last time. The court recognized in a recent decision that these entities certainly are here and operating, and recognize the need for some regulation. So that is the intent behind the bill. And maybe Mr. Cocking can fill in the gaps.
Mr. Chair, I would piggyback on what Senator Seeberger said. Not only does the court address this, the court, and this was, I think, Justice Moore's concurrence in the Maslowski decision, said, for these reasons, it would be beneficial for the legislature to address these concerns through regulation of the litigation financing industry in Minnesota. And so I think that this decision, I think, was 5 years ago. Excuse me. The legislature still hasn't done anything on this. I think it's high time that the legislature takes heed of the court and does something to get around these people who are driving up premiums for everyone in Minnesota.
Other comments, questions? Mr. Carlson?
What?
Sorry. Oh, and while he's coming up, Tim Johnson online has a comment.
Yeah, thank you, Senator. I my only reservation on this is we didn't hear from anybody who might have an opposing opinion on what the effect of this could be on that marketplace. So I think it's the only topic that we've covered that really didn't hear from anybody who might have a differing viewpoint. So for that reason, I'm not sure that the committee should recommend it, because they haven't really heard any dialogue from any of the stakeholders. Thanks.
There's lots of testimony on the record, and we have the responsible opposing viewpoint at the table right now.
Right, it might be more than one of us, Mr. Chairman. Hi, Aaron. So, Mr. Chairman and members, I'll introduce myself again to this commission directly, which I've done before, but no one will need to clarify who I represent. I'm Joel Carlson. I own a legal research and government affairs business here in St. Paul. And since 1994, I've represented the Minnesota Association for Justice. This organization has been in existence since 1954 and works to protect the constitutional rights of Minnesotans when they're injured, have their constitutional rights denied, face delay and wrongful denial of their insurance claims that they have against their own insurance companies. And we represent plaintiffs in these matters. Access to justice, a trial by jury, our right to due process, and our constitutional right to redress are central to the mission of our organization. And these seem to be particularly important things to be reminded of at this moment in time. You know, we've been here throughout this task force. We provided some testimony. We provided factual information to you about the tort system in Minnesota and around the country. And it appears that the focus of the insurance industry here is to pass this Consumer and Crisis Act. And it's easy to see why, not only here in Minnesota, but this effort's going on around the country and in Congress, that the insurance industry is pushing for this. A resourced plaintiff that can withstand delay and the cost of prosecuting your meritorious claim is a threat. We appreciate that. But let's back up and see what you've heard about what justifies the push for this legislation. You've heard some catchy PR phrases. For example, we're talking about a tort tax. There's no such tort tax. The tort tax was invented in the 1980s by an insurance industry consultant, and it is a combination of every imaginable cost you can imagine that we pay in insurance premiums, insurance executive compensation, advertising. They paid $14 billion in advertising last year. All of that goes into the tort tax. It is a completely fictitious methodology for making it up. And there's no more tort tax than there is an excessive insurance industry CEO compensation tax. It is completely made up. They also claim that litigation claims are skyrocketing. Yet the information that we submitted to you from our own Supreme Court said that personal injury cases are down 23% since 2018. There's just no litigation explosion. Another issue that they brought on the table, nuclear verdicts. Let's look at that. Most of the verdicts that they're talking about, they haven't told you this, is business to business litigation. Like the group of farmers that had to sue Syngenta when they were sold altered seeds and couldn't sell their products around the country. That's a nuclear verdict. It's not a personal injury case. And since 2009, there have been just 6 such verdicts in Minnesota. Only one was a personal injury case, a woman who was killed through a medical malpractice mistake during childbirth. And lastly, we have this bill in front of you, the Consumer and Crisis Act, which is another catchy phrase that we're seeing across the country. And it relates to consumers who have claims. And I think the title is particularly disingenuous. The reason they're in a crisis is they can't resolve their claim with the insurance industry. That's why they're in a crisis to begin with. And this bill does nothing for them to help them resolve their claims. In fact, the bill itself does nothing for consumers. What it only does to change what is currently going on right now is that it mandates disclosure of non-relevant information to the insurance defendant during the pendency of litigation. And where that has been disclosed, the experience has been that it just delays the litigation because the longer the consumer has that loan, the worse it becomes for them. There's no evidence that this is costing anybody anything, but that loan, and we're not here to advocate for the industry, but that loan is sometimes the only way a consumer can pay their living expenses while they pursue a meritorious claim. And they're only in that crisis because it's not being resolved and is being delayed. So that's what we're talking about here. I'm happy to talk about the content of the bill, the violation of the attorney-client privileges that are in this bill and other areas. And the commercial part of it, Mr. Chair, is completely unacceptable, has nothing to do with these claims whatsoever. So we're not here at the table. We can't raise our fist to these. We're happy to work with you, but there isn't any evidence that this bill as a recommendation would do anything to save costs for consumers, and we're adamantly opposed to it.
And Mr. Hines, did you want to speak as well? If so, can you introduce yourself for the record?
Thank you, Mr. Chair and members. For the record, my name is Patrick Hines with Messerly Kramer. I represent the Alliance for Responsible Consumer Legal Funding. We abbreviate that as ARC. There is a memo in the packets, I believe, and out front that gives a little more detail to what I want to briefly testify about. ARC represents organizations that provide consumer legal funding. There's a distinction between consumer legal funding and third-party litigation funding. The legislation that's been under discussion deals with both. But as I have watched the task force meetings, I've really only heard discussion about consumer litigation funding. And so my organization's concern is that if the task force members wish to support a piece of legislation that regulates both products, I would strongly recommend that the recommendation, if you make one, focus simply on third-party litigation funding. And very quickly, the distinction, third-party litigation funding you've been discussing, where there's perhaps millions of dollars of money being transferred to allow a law firm or the plaintiffs to litigate a case. Consumer legal funding is much smaller scale. The most relevant example would be an individual who was in a car accident. They have a case pending and the case may go on for 12 months or 18 months. And at some point, maybe because they've missed work as part of the accident or have medical bills, they're struggling to pay rent and food, utilities, basic expenses. They can get money, usually in the range of $3,000 to $5,000, based on the anticipated outcome of the trial. And that money is advanced to them through one of these organizations. There's no consumer reporting, there's no background check, there's no collateral, and it's non-recourse. So if your case doesn't succeed, if you withdraw the case, if the jury doesn't find in your favor, you don't pay that money back at all. So that consumer legal funding is fundamentally different, both in scale and also in purpose as the third-party litigation funding. I just want to draw members' attention to that as you have these discussions and perhaps make a distinction between those two if you're going to recommend action by the task force. Thank you.
Okay. Members, I think Anna, did you want to speak? So we have one more. So come on up and introduce yourself for the record.
Hi, Mr. Chair, Task Force. My name is Anna Odegaard. I'm with Minnesotans for Consumer Financial Protection, and I broadly agree with the testimony you've heard, but I'd like to speak in very plain language about the concerns of consumers, about the TPLF and other tort reforms that have been discussed and considered in the task force. I know there's been a lot of speculation about the potential cost savings that might benefit consumers, including it might reduce costs by some unknown amount, and which might be passed back to homeowners through lower premiums. I'd really like to ask the task force to focus on, with these uncertain benefits, what are the certain harms that have to be weighed against whatever possible benefits there might be to consumers? Because the problem in a nutshell is that while the proponents are saying this for reform is needed to rein in frivolous lawsuits and what did you call them, nuclear verdicts, none of these remedies are tailored to frivolous lawsuits. The proposals are just as restrictive and create the same hurdles to accessing justice through the courts for homeowners with legitimate complaints as for those with so-called frivolous cases. As we've just heard, these restrictions on TPLF and other kinds of funding shifts a financial burden of seeking justice through the courts onto individual homeowners and other plaintiffs, including plaintiffs with legitimate reasons to challenge a claims denial or lowball by their insurance. This basically means that homeowners that can't afford to finance their own cases aren't able to make their case in court. And making it difficult and expensive for a homeowner with a legitimate complaint against their insurer to take legal action is a significant harm to a consumer. It not only hurts that individual consumer, but in that consumer may have paid premiums for years to make this claim when disaster hits them. But it also undermines accountability for the industry by reducing the incentive for them to settle all claims fairly and quickly. So as this task force considers this TPLF reform and other reforms, I'd like to ask you to weigh those possible benefits that you've been speculating against this certain harm to consumers. And I would also like to just speak briefly to the potential cost savings. I brought a handout that is made of NAIC data, Weiss Ratings, which is an independent ratings company, put together in a pretty map. But there's also an NAIC dashboard database that you can search all this information. It's easy to access. Would be happy to share that with anybody. Could I pass this out?
Sure.
That'd be great.
And to see what this is, but this may have been posted already in some form. Let's see.
That's possible. I'm happy to share a link to the entire report. I just printed one page instead of 29 or something, because I've just got a little printer at home. So basically, this is showing, what this map is showing is the lawsuits filed in 2024 by homeowners as a percent of claims closed without payment. So you'll see that Florida, which we've talked about a lot in this task force, leads the nation at 12.9%. That means that in Florida in 2024, of homeowners who filed a claim with their insurance company, of homeowners whose claims were denied by their insurance, about 1 in 7 of them end up suing their insurance company. I don't know the merits of those cases, but that does seem high, right? 1 in 7. But in Minnesota, 0.6% of homeowners whose claims were denied in 2024 sued their insurance company. That's like 1 in 167. So it doesn't seem like the data supports a need for significant restrictions that would make it harder yet, especially for low to middle income Minnesotans who can't finance their own court case, to take legal action. And the other point I'd like to make, which actually I think is contained in the letter that Mr. Carlson submitted, is that we haven't heard a lot about the actual cost reduction that's even possible through reforms like these restrictions. Insurance companies report to the NAIC on these costs. They're called direct defense and cost containment, DCC costs, and they're reported to the NAIC on an annual basis as a percent of premiums earned. So as a percent of every dollar or $100 earned in premiums. What do those insurance companies actually spend on DCC, these cost containments? Nationwide in 2024, for homeowners insurance, DCC was about 1.5% of premiums earned. So for every $100 in premium that the industry took in, they spend about $1.50 on these direct cost containments. But we know from this map that Minnesota is way below the national average. So it probably wasn't 1.5% in Minnesota if we look at these numbers from the NIAC. And just to make the math easy, I laid this out for consumers who are actually looking at a bill in their hands, sitting at their dining room table looking at their bill. Let's say it's 1%. Across the country, it's 1.5%. We know Minnesota is lower. To make the math easy, let's say it's 1%. How much can we expect tort reforms like this to save consumers? I think that the proponents should answer that, but this was my back of the envelope math. Let's say tort reform is wildly effective and it actually cuts costs for insurance companies by half. It probably won't, right? Like it might reduce it by 10% or 20%, because people with resources will still be able to sue their insurance companies and they still will. So it won't eliminate those costs. But if it's wildly successful and it reduces costs by half, then that 1% in Minnesota might be dropped to 0.5%. So in other words, the insurance industry, for every $100 they take in premium, instead of paying $1 of that for court costs, maybe they only have to pay 50%. They save 50 cents. We've heard in this committee that the industry will pass those costs, pass those savings back to the consumer in the form of lower premiums. Empirically, we have not seen this happen in other states that have enacted tort reform, but let's give Minnesota insurers the benefit of the doubt. Maybe they'll split that savings with the consumer. So they save 50 cents on every $100 of premium they earn. Say they split it with the consumer and they pass on 25 cents of savings for every $100 of premium earned. What that means for somebody with a $2,000 homeowners insurance premium is that they will save $5. If they have a $4,000 insurance premium, they will save $10, which is savings. But in exchange, we will have made it practically impossible for most low to middle income homeowners to actually access justice through the courts if they are in a dispute with their insurance company. And I wanted to lay those numbers out in a clear way. I'm not a lawyer, I don't talk like a lawyer, but I think most people can understand that savings of $10 off $4,000 on their premium weighed against significant hurdles to accessing justice through the courts is not a good trade-off. We heard from the Beltrami County administrator about folks in his county that were really having a hard time with their insurance company getting their claims settled. We don't know exactly what happened in those cases, but we know it is a reason for concern, which is why I want to come back to one last point that came up a lot in this committee, which is around, we heard around these tort reforms, maybe it's not a crisis now, but we should get ahead of the problem. And I am all, as a parent of teenagers, all for getting ahead of the problem. And I actually think that this is something that is a really legitimate concern on this issue in particular, because we've also talked a lot, you have talked a lot about the rise of surplus lines coverage for commercial properties for sure, but more and more across the country and in Minnesota for homeowners. And the thing with the surplus lines coverage that's been talked about here is that they're not subject, these surplus lines companies are not subject to state regulators, right? They are licensed in other states, but that licensure almost exclusively deals with capital requirements, not consumer protections like we have in Minnesota for the standard insurance companies, like protections against unfair cancellation, right? Fair notice of cancellation or non-renewal, requirements for fair and timely claims processing, in addition to the Minnesota Guarantee Fund, right, which got talked about a lot here. There is no surplus lines company that I'm aware of in other states where other states are imposing that kind of consumer protection on their surplus lines carriers that are functioning in Minnesota. If somebody knows otherwise, I think that is information the task force would definitely like to look at. But what that means is that as a practical matter, someone who holds a surplus lines policy has no other recourse except the courts to hold their insurance company accountable because they can't turn to their state regulator for help. When the Beltrami County administrator was talking about the trouble his constituents were having getting their claims settled, a member of the task force pointed out that those companies are regulated by the Department of Commerce, and those individuals should make a complaint to their regulator if they were unhappy with the way their claims were being processed by their insurance company. That is a fair point. I don't know if any of those Beltrami County residents had surplus lines policy on their homes, but we know that that is a growing line. Anybody who has a surplus lines product can complain all they want to the Department of Commerce. They don't have authority over these surplus lines. Those folks are going to need access to the courts. And so I agree it's possible we'll see an increase in lawsuits against insurance companies as we see an increase of surplus lines policies in the homeowners insurance market. But I would argue that that's an even better reason that we maintain access to the courts for regular homeowners who would not be able to finance their own case. That's what I wanted to share with the committee. I really appreciate the time.
Members, any comments or questions? Mhm. Senator Seeberger?
Thank you for your comments. I want to clarify that there's nothing in the Consumers in Crisis Act that prevents a litigant from bringing their claim in district court. There's nothing, and we've never claimed that this bill is meant to address frivolous litigation. There is nothing in this bill that would stand in the way of a litigant bringing their claim. This doesn't prohibit a litigant from obtaining financing to bring their claim. It doesn't prohibit it unless the financing company is a foreign corporation. I question whether some of these testifiers have even read the bill. A lot of this is consumer protection related. If you look at Section 3, it sets forth contract requirements for third-party litigation funding contracts. And the intent is to protect the consumer from predatory practices. For example, the contract must be written in clear and coherent manner using words with common everyday meanings that enable an average consumer who makes a reasonable effort under ordinary circumstances to read and understand the contract's terms without having to obtain professional assistance. That to me sounds like a consumer protection provision. I don't read that to mean it stifles a litigant's ability to bring a claim against their insurance company. The next section of Section 3, the next subdivision. A consumer litigation funding contract must be completely filled in when presented to a consumer for signature. It must contain in 12-point bold font type a right of rescission that allows the consumer to cancel the contract without penalty or further obligation if within 10 business days after the funding date, the consumer returns to the consumer litigation funding company the full amount of the disbursed money. It must contain the consumer's initials on each page. It must include a statement that indicates the consumer is not required to pay a fee or charge other than a fee or charge disclosed on the disclosure form. And it goes on. There are 8 subdivisions under Section 3 that contain consumer protection provisions in this otherwise unregulated field. That seems to be precisely what the legislature should be doing. Subdivision 2 brings the attorney into this. Subdivision 2 provides that the contract must contain a written acknowledgement signed by the attorney that attests to the following. Various items, again, that protect the consumer. The next subdivision contains a termination clause, setting forth how a consumer can terminate the contract. Section 4 talks about prohibitions and charge limitations, again, to protect the consumer. Section 6 talks to disclosures. This is shedding daylight on everybody who's making financial decisions when it comes to a litigated claim. I will tell you, in my experience, as a trial attorney for 30 years, I'm a trial attorney, not a plaintiff's attorney. I'm a trial attorney. I've tried many cases before a jury. And I've mediated even more. And I can tell you, when we're in a mediation, some cases move along in a predictable pattern. Some cases get hung up. And a lot of times I'm over there scratching my head saying, why is this not getting settled? What is the obstacle here? And my suspicion is there's another funding source behind the scenes driving the ship. Wouldn't it be nice if we all knew in the mediation who the participants were in the process? Wouldn't it be nice as me, as a defense attorney representing my insured, whoever they may be, whether it's an insurance company, whether it's a property owner, whether it's a contractor, or whether it's an individual. Wouldn't it be nice if I'm in a mediation and I can then understand, oh, there's a third-party litigation financer out there that is phoning into the mediation? Wouldn't that be nice, so that we know what's going on? So that I don't walk out of a $1,000 full-day mediation scratching my head, I don't know what the heck happened, and it drives it toward trial. That's what the disclosure section is all about. It provides remedies to the consumer. If a consumer litigation funding company willfully violates this chapter, that's Section 7. It provides for registration of the company so we can ensure they are a valid company. They're not a fly-by-night organization that comes in to defraud people who have a claim. There is a reporting requirement, again, to expose daylight on some of these practices. Prohibitions in Section 12. Commercial litigation financer is prohibited from directly or indirectly entering into a commercial litigation financing agreement with a foreign entity of concern or a foreign country or person of concern. There's a disclosure requirement. That's the bill. Where in here does it prevent a litigant from filing a lawsuit? That's my other bill I'm bringing. That's the mandatory binding arbitration. You've heard me talk about that a bazillion times. There is nothing in here that prevents a litigant from having their day in court. There is nothing in here that impedes the litigant's relationship with their own attorney. There's nothing in here that even talks about frivolous lawsuits. I don't know how we ever got that idea. This is a consumer protection bill. If there are provisions that Mr. Carlson or other parties would like to talk about and have a conversation, I am open. My door is open. Let's talk about it. Certain provisions don't work. Let's talk about it. I filed this last session. Nobody has come to my door. Nobody. I make that invitation. Let's talk about it. But from a consumer protection standpoint, that's what this is for. And if we can take any action to lower the costs of premiums when it comes to property insurance, then shouldn't we do that? Shouldn't we do that? We can talk all day about speculation, whether it will or whether it won't. But we can make all those same arguments when it comes to our discussions with regard to the FAIR plan, with regard to a savings account. Is that going to help? I don't know. Geez, I think it might. So why are we holding this particular concept to a different standard? That's all I have, Mr. Chair.
And I'd say this is the discussion I was hoping we would have last time, but
Mr. Chair.
yeah, he wasn't here either.
Right.
Mr. Cocking?
Yeah, I mean, hard to get on the back of that. But I would say the one ththing kind of in Senator Seaver's point to closing was, the question about whether or not we don't know whether this is going to happen and we're speculating on this other stuff. I mean, I think, again, and I'll come back to the point that I've made previously. I mean, all you have to do is look to the reforms that Florida made to see the actual decreases that they are seeing in their insurance market. I mean, insurers are sending back billion-dollar premium credits to their policyholders as a direct lineal result of the tort reforms that state enacted over the last handful of years. This chart that was handed out that shows the 12.9%, the context behind that, as I understand it, is that when the Florida made their lawsuit reforms in 2023, there was a 2-year point that basically you had to get all of these things wrapped up. And so every plaintiff's attorney ran to the courthouse to get their claim in the system, which is why it looks so a little bit of context I think is helpful. One final thing, and I'd like to ask my friend, Mr. Carlson, because I just want to make sure, you had said that, and I'm paraphrasing, so correct me if I'm wrong, that the amount that these lawsuits, and in essence that the plaintiffs bar are bringing, have no bearing on insurance costs whatsoever, that there's no impact to costs as a result of the lawsuits that are brought by plaintiffs' attorneys?
Mr. Carlson?
Thank you, Mr. Chairman, and members. First, as to Florida, let's make sure we know that Florida hasn't passed this bill. This isn't part of one of the reforms they've passed. In fact, they're having a hearing on it next month. They haven't passed this. This isn't anything that brought down any insurance rates in Florida. I can quantify for you how much these cases cost because it's right in the Insurance Information Institute documents that's in the file that we put in the file. It's 2.1% of losses. Liability cases are 2.1% of losses. That includes what the injured party got and what the defense costs were. So we can quantify it. We do know 2.1%. So we do know that. And you really are not telling the committee what was litigated in Malachowski. One of our law firms litigated that case for 10 years on behalf of a consumer. And what did the Supreme Court say? Number one, these loans are legal. That was first trip to the Supreme Court. Number two, we can't tell if the rate in here is usurious. And number three, we can't tell if a 60% interest rate is unconscionable. Those were the things the court said the legislature should address. This bill doesn't do it. This does nothing to cap the interest rate. It does nothing to cap the amount of the loan. It does nothing to cap the fees. Those were the complaints in the Malachowski case. This doesn't do it. And I strongly disagree, Senator Seeberger, that this doesn't interfere with the attorney-client relationship. If you look on page 5 at 5.28 and 29, it specifically precludes a lawyer from discussing the tax, financial, and public benefits of a consumer loan with their client. You can't tell them what this is going to do to your ERISA claim. As a railroad worker who has no workers' compensation, you can't tell them under this bill what the consequence of coming into a consumer litigation finance loan is for them. I absolutely disagree that this doesn't interfere with the attorney-client relationship. It also requires you to acknowledge the loan. It requires you to disclose information to the funder if they're doing it, if they ask for it so that they can assess the claim. That's interfering with the attorney-client relationship. There are a number of things in this bill that are problematic. That's just a couple of them. The discovery aspect of this and having this not relevant information become discoverable. If they want it right now, they can make a motion to the court to say, I think this is relevant to this case. They can do that right now. There's no prohibition on them from asking for this information right now. But it's not relevant to the underlying facts of the case. And I will stand up for the bar, and I've taken a lot of arrows for lawyers in the last 30 years, but I believe they follow their ethical rules under Rule 1.8 to let the client determine their case and let the client decide what goes on. There isn't some third-party litigation funder in the room saying we can't accept that amount. And I'll defend your ethics and every other lawyer's ethics until I am convinced otherwise, that they've been disbarred for illegal or unethical conduct. I'll defend their right and their obligation to their client to let them decide the merits of their case.
Jessica Samansky?
Yeah, I just wanted to follow up the I'm so sorry, I forget your name, sir. Joe. To add that, like, I think the representation that this bill is designed to solely protect consumers is disingenuous. There are certainly some sections in here that are geared towards like making sure the contracts are fair, but then it goes a step too far to add provisions that stifle the ability for parties to freely contract as they should be allowed to do. I noticed when Senator Seeberger was reviewing what the different sections do, she skipped Section 5, which completely destroys how third-party litigation funding arrangements are designed to operate. They operate by contingency. And if you take away the ability of plaintiffs to be able to fund these agreements by contingency, then it effectively prohibits consumers from entering into these contracts in the first place. And so even though nothing facially prohibits consumers from being able to take advantage of this access to justice tool, the reality of how this functions does in fact cause consumers to lose out on the opportunity to enter into these contracts and have access to their day in court. I also, similarly to the testifiers, have grave concerns about the disclosure requirements. The key to discovery should be information that is relevant to the issue in the case and how a client or how a plaintiff receives funding to fund their litigation is not relevant to the merit of their claim and the facts that underlie what claim they're trying to litigate. And it simply is just like providing opportunities for corporate defendants to take advantage of knowing what these funding arrangements are to like use tactics to exhaust the budget of what their funding source is. And if we're so concerned about the effects of like these players having an impact, then it's completely like Joe was saying, it completely like undermines the like rules of professional conduct that lawyers are expected to adhere to anyways and assumes that lawyers aren't following those rules. We already have mechanisms for ensuring lawyers follow those rules. So we should be ensuring those are followed rather than coming up with tactics that just decrease a consumer's access to their day in court. I think it's interesting that like we're talking this act to protect consumers requires disclosures of third-party litigation funding, but it doesn't talk about like requiring disclosures for like companies that have reinsurance. If we're saying this needs to protect consumers, it should go both ways. The corporate defendants should have to reveal information about their funding sources as well, but this doesn't do that. Thank you.
Okay. Mr. Johnson? Tim?
I had put my hand down because Jessica had covered a lot of things that at least came to my mind. And I'll be clear, our firm does a lot of plaintiffs' work, but only in the property insurance space. And I think one of the things that the committee has to be really cognizant of is the reforms in Florida were because they had a statute that allowed the owners of property to recover their attorney's fees if their insurance company was off by $1. Minnesota doesn't have that. If you look in our case history, our bad faith statute 60418, I bet you'd find one of more than 1 million property cases where that statute applied. It rarely does, and it only provides up to $250,000 in additional compensation. And then that only applies to the fees that the insured spent pursuing that bad faith action. So these extra or punitive damages don't exist. I can't tell you the number of clients that my firm talks to about a carrier that may have turned down their claim. And then when faced with the cost of litigation, knowing that they will never be able to get that money back, they don't pursue their claims. I would be concerned that doing anything to restrict people that are willing to fund that in the market would be bad for business. And I got to tell you, I have never talked to a litigation funder. None of my clients have ever used a litigation funder, but as somebody who is sort of tangentially involved in those types of lawsuits, kicking those people out of the market is going to reduce the ability for a lot of people who don't have the money for our court system to be able to be in it. And that would be my concern as a consumer, not an advocate. As somebody who lives in a state, there's a lot of people that can't afford our court system. So I would be very, very cautious, and I would have a lot of hesitation about something that might push people out of the market that can help people fund it. So those are the points I wanted to make. We're not Florida. We don't have those punitive damages. You wouldn't even find a bad faith about that as a group, that we don't allow consumers to have even less access to the courts than they already do. Thank you.
Okay. Anyone? Mr. Axfig?
Thank you, Mr. Chair. I just have one question for Mr. Carlson. In the memorandum provided to the task force, and again, in his testimony, he brought up this 2.1% of paid losses. Is that frequency? Is that total dollars paid out? Just curious what that number is.
Mr. Chair and Mr. Axfig, I can run back to my thing. I know it's in the III insurance information that number came from. And I believe when I read the footnote that the 2.1% in 2023 or 24, whichever it was, of claims paid represents everything paid to a liability claim and their cost to defend. So that's where it came from. And I'm sorry, I should have brought my entire file up with me, and I can get it for you. But that's where it came from, and I did provide the link in that memo to that information.
Yeah, Mr. Chair, I only ask because if it's just a number of claims, so out of 1,000 or 100 claims, 2 of them happen to be liability losses, that's effectively a meaningless statistic. And I apologize, but I mean, unless you're addressing the severity of the claims, if I go buy $100 worth of pull tabs and 2 of them are winners, do you know if I won or lost? Because you don't know what I won, right? And so, and not to use that example, but I think it's relatable. It's essentially, it's not helpful as far as I'm concerned for the task force to look at a number like 2.1% because it's not painting the whole picture. Insurers have to look at frequency and severity. If the frequency is low, but the severity is off the scale, it is going to impact premiums. And so I just wanted to bring that point up, that without that additional information, it's really hard to be, to have any sort of actionable point of view on this. So that's all, Mr. Chair.
Thank you.
And Mr. Chair and Mr. Axfig, I think that number is available, and I think the claim severity on the liability is only, though it's 2.1%. I want to say it was around like $31,000 per claim, and a homeowner claim, property claim was, let me make sure I look, but I thought it was around 18,000. So it's definitely higher than what an average property claim was.
Yeah, Mr. Chair, I would just like to add on to that. So, with that being said, we could stipulate that the severity is higher, but I would also say that the risk of severity is much greater. If you're looking at property damage or roof or fire, or whatever, you have a fixed cost of which to build your premium off of there, right? If your house is worth $500,000, if it burns out, you have an idea of what you're going to have to pay out maximum. With liability claims, that's a little bit more ambiguous. You have no idea what the limit could possibly be, and insurers have to build that into their pricing model. So I just wanted to bring that to the task force's attention that there are more unknowns riding along with this here. And insurers have to build that into their pricing in order to accommodate for that.
And Mr. Chair.
Mr. Carlson wants to run, and
Actually,
then
let's be
Senator
clear.
Seeberger would like to speak as well.
My homeowner insurance policy and yours has a limit of liability that the insurance will pay. So they do know what their maximum exposure is, even in a worst case scenario. So they do know. To say it's just unlimited or
Correct.
unknown.
It-
That's just not quite accurate.
And I would say, Mr. Chair, yes, that's while it's true, I would say your limit is probably likely higher than the average severity height listed in the Triple I's data here. You know, he said $30,000. I presume your limit's higher than that, and so the potential is much higher. Which again, that ambiguity has to be built in.
But they've rated for it.
Senator Seeberger?
Thank you, Mr. Chair. In the context of litigation, the policy limits is not the only thing that an insurance company pays out. The insurance company pays for their experts, they pay for their legal counsel, they pay for merits counsel, and a lot of times coverage counsel. And those expenses are separate from liability limits. So while the ultimate payout on a verdict or settlement is defined by the liability limits, the costs incurred in defending the claim are in no way tied to those liability limits. And I do think we need to make a distinction here. We're talking, if Mr. Carlson, you were talking about liability claims, which are wildly unpredictable when it comes to jury verdicts. But most claims, we've also been talking about suing your insurance company. That's a breach of contract claim. That's not a liability claim. That's a breach of contract claim. And there's also bad faith claims, which is something entirely different. So if you're pulling numbers out, speaking to liability claims, but what this work group is talking about is suing your insurance company for failure to pay a claim or something, that's a contractual, that's a breach of contract claim. So I haven't heard any of those numbers. I think we do have to keep in mind what we're talking about here and differentiate accurately what it is we're talking about in this context. I just wanted to point that out.
Mr. Cox?
Mr. Chair, I just wanted to clarify one other thing too. On the notion of who is controlling these lawsuits, and it's not, again, me that was saying this, and I'll take from this concurrence again that says that there are legitimate practical concerns about the effect of unchecked litigation financing agreements on plaintiffs and defendants alike. Such agreements may interfere with plaintiffs' ability to control litigation and settle. And I think that's a key part of this, that once you enter into one of these third-party lawsuit funding agreements, absent the Consumers in Crisis bill that Senator Seeberger has authored, you don't necessarily have control when you decide that you want to settle. And those increased costs as a result of this person behind the scenes that's pulling the strings drives to higher costs that lead to higher premiums. There is a direct correlation there.
Thank you. Mr. Brickwitty?
Thank you, Mr. Chairman. As ever in my legislative career, I was always endeavoring to avoid the Judiciary Committee at all costs. Here, I find myself in a hearing having broken out. Mr. Chairman, I think I'll repeat what I said at our last meeting about this proposal. I think the department thinks that this is a worthwhile topic for us to be pursuing. I appreciate Senator Seeberger bringing the bill forward. I think I'm not going to comment on the merits of the discussion, but I think the discussion shows that this is a worthwhile piece of legislation that should be looked at carefully. I think I would come back now to what I said right at the beginning, which was the wording of this recommendation for the task force's purposes strikes me as perhaps something that we will not find consensus of on this precise wording. I think we would, again, the department very willing, and I'll leave it to smarter colleagues than myself to participate in the discussion of the substance and engaging on the bill as it moves through the process. I think we would have no concern about the wording of a recommendation to say this should sort of like, we should have a hearing or we should move this through the process. And I don't know if we need to wordsmith that here. Perhaps we could bring it back at the next meeting. But I think this precise wording gives me a little bit of pause just because of the discussion that we've been hearing today. But again, I fully believe that this is a topic that we should be looking at during the legislative session.
Yeah, that's kind of where I'm coming out as well. But I think we would probably, since we only have one more meeting scheduled, I think we would want to, if, you know, if Mr. Brick, if you've got some suggestions on what you think it should say, that would be great. And we wordsmith it a little bit at the next meeting, but we probably would want to be closer than where we are right now. Oh. While he's thinking, Senator Dames has a comment to make or a question.
Well, thank you, Mr. Chair, and I think we want to be cautious. This bill is an active bill. This bill was introduced in March of 2025. If I remember right, it was introduced after the deadline. So this bill is in front of the Conference and Consumer Protection Agency. And I think we want to be cautious what kind of recommendations and stuff we're making here. This bill is a standalone bill going forward, and I've been around 16 years, and I'm very surprised to hear that we're going to start making recommendations and stuff for a live and active bill that hasn't even had its first hearing. And so I think we want to be a little cautious how we proceed here.
Yeah, I think you're in violent agreement with Mr. Brickwitty.
Mr. Chairman, I welcome the company. Senator Seeberger, I'd maybe defer to you as the author of the bill. It seems like we're sort of having a version of a hearing right now. Perhaps the recommendation is from the task force to the legislature is that the legislature have a hearing or something along those lines. But I just would be cautious, excuse me, about the wording that we have in the document right before us today. But again, I don't want to get into the merits. That's beyond me personally.
Senator?
Thank you, Mr. Chair. And good catch. I agree. I don't know as much as I love my bill. I don't know as a task force that it's appropriate for us to come back to the legislature and say, we recommend that you pass it. I am grateful for the discussion. I would like to continue the discussion. I think it's appropriate as a task force to make recommendations that this issue be explored or the bill have a hearing or something like that, because I feel like we've hit on a topic that needs further exploration through the bill drafting process, the committee hearing process, and this is no substitute for that. So I would probably vote no on draft recommendation number 6, but I would support a recommendation that directed the legislature to at least consider regulations around third-party lawsuit funding using this particular bill as a starting place.
I like that idea. I see a lot of nodding heads around the room. Yeah, Josh Reams. Yeah. Anyone online? Senator Daines?
Well, thank you. I'm not so sure that we want to be recommending somebody has a hearing, and I'll tell you why. That's the decision that the chair of the committee will make. And I don't think we need to start referring things now and saying that the committee should do this and the committee should do that. That's not what this task force is here for. I think we've had some very good discussion today. I think it's a discussion that was worth having. But I think the next step is to keep our nose out of it and let the chairman of the committee and let the author of the bill, let them work this out and let it go through the process. And Mr. Brickwoody, as far as a fiscal note, probably hasn't been one, I would assume there probably hasn't been one done because of the lateness of the bill. But with that said, I hope that when we get into session within a couple of weeks, I hope this is you representing the Commerce to the legislature that you watch, and when we get a bill in that's in the third or fourth hearing and hasn't had a fiscal note, I hope that you'll track those down and make sure those get done. Thank you.
I think we can make a recommendation that a bill be heard. It's nothing we say here is going to be binding on any committee chair in terms of what they choose to hear or not hear. Huh?
Well, way, we can
Senator
pretty much
Daines?
do, we can do, sorry, Mr. Chair, thank you for being recognized.
Yeah.
We can do pretty much what we want to in this task force. I understand that. But I don't think it's in our best interest to start recommending that hearings be held by committees. I think we're crossing the line, and you may not agree, and that's fine. We'll agree to disagree. But having been a chair of committee many years, I don't think we need to be telling the chair that we suggested to hear it or we recommended to hear it. The bill will stand on its own merit, and chances are this bill will get a hearing. And that's when a lot of things we're discussing today can be brought back up in front of the committee where there can be action taken. So I would disagree with the recommending that we do, that they should be doing a hearing. I don't think that's where we belong.
Thank you, Mr. Chair. Perhaps we can do something short of recommending a hearing, certainly recommending that the legislature, whatever the first part of what I said was, recommending that the legislature examine regulations concerning third-party lawsuit funding, and that Senate File 2929 is a good place to start. It at least tees up the topic, lets the legislature know that we've spent time on this issue, takes into consideration Senator Dames's concerns. Maybe that's the way we go. Just spitballing over here.
I mean, we could also pull verbatim from the Supreme Court decision that says it would be beneficial for the legislature to address these concerns through regulation of the litigation and finance industry in Minnesota, but maybe that's too simple.
Well, I tell you what, I think we've had a really good discussion. Like I said, I was hoping we'd have this last time, to give her some more time, you know, before our last meeting. But we did need to have this discussion, and I think, you know, staff has been listening to this. Let's leave it to us to come up with a draft language for this to include in the program. And as soon as we have something, we'll circulate it. So that we don't have to spend all day. So I think we still got one or two more left to go, but I think we're kind of close to a consensus on what we want to say on this. Okay. All right, Kate, let's move to the next one.
Thank you, Mr. Chair and members.
Yeah, thank you.
Thank you, Chair and members. So last recommendations for today. So this is draft recommendation number 2. And Chair Elkins, would you like to comment on this or ask any other members to
I'm
speak
sorry,
to
this
this?
is the Fair Plan Governance Model item?
Yes.
Yeah, okay. So Carrie Johnson, I think this is, you're probably the best person to kick off the discussion on this one.
Sure. Thank you, Chair. I wasn't aware this was going to be put on here. So, but yeah, I did bring it up in previous comments. So we'll just say, you know, I think I would like to see some more public members on the Fair Plan Board and kind of see if there are other additional structural changes along with financial needs that the Fair Plan should request from the legislature in order to expand product offerings. And, you know, I'm guessing not everybody's going to support this. And so I'm fine also with leaving it more broad and maybe having those discussions during the legislative session for more detail.
So do members have any comments or questions or about the recommended language or the drafted language for this one? Mr. Rickwitty?
Mr. Chairman, just a purely technical thing on the wording of the recommendation. I don't think that the FAIR Plan alone could update the board composition in any way because it's set in statute. So I think a change to the board composition would require legislative action. So just a note that we would want to, if we were going to advance a recommendation on this, we would need to probably update that recommendation language.
Yeah, and I think Ms. Johnson recognizes that. Any other comments?
Mr. Chair, I mean, I would reiterate what I've said previously. I mean, as far as the first part of this recommendation goes, and there's a lot to this, but the complete non-starter would be the board composition. Recognizing how the FAIR Plan works, that when they run a deficit, insurers are assessed to make up the difference. Would absolutely not support putting people on who are not going to be paying that assessment or be responsible for it. I just don't think that's wise.
Mr. Chair, I would say that this became much like number 6. It just got too specific. I mean, the FAIR Plan was a conversation of a concept that could or could not help, and we want to recommend exploring it. I think we all agreed on exploring, but now this gets really specific to recommending mechanics of it. And I don't know that we're there or if that's our role.
Mr. Chairman, maybe a follow-up question for Mr. Cocking. Aren't policyholders paying that assessment? Members of the public? I don't quite understand the logic behind your objection.
Well, let me try to make it to you. And what do we require insurance policies be written in ninth grade reading level, 8th grade reading level? Yeah, of course, the policyholders are, but when it comes to, they're not paying the assessment in the same way that, I mean, the insurers are going to be the ones responsible for it. You want to have people that are looking at this that are making sure. It's the same way. If you give me your checkbook and you say, hey, go, buy whatever you want, do you think we're going to have the same level of responsibility in what we purchase? I don't think we would. Maybe we would. I don't think that we would. I just don't think it's, I don't think it's responsible to put people that don't have public members an oversized amount based on insurer members. I'm not aware of anywhere else that's done this, but I'd be open to that as well. I mean, we could take it out of the Department of Commerce budget if you want to. I mean, in that sense, it's all, I mean, we want to do assessments out of that and pay for these deficits. I mean, that's fair because then we're all paying for it because it's the state of Minnesota. We're collecting through the general fund. I mean, that's fine too.
Mr. Chairman, I think we're conflating a couple of different things, and I don't disagree with Mr. Ream's analysis that this might be an overly prescriptive recommendation. I simply would say that there are numerous examples within the state of Minnesota of quasi-public entities that have boards that have either a 50-50 split between public appointees and industry representatives. And there are also examples of FAIR plans that do have a public member majority in other states. Now, I will also say that Minnesota's current FAIR plan board composition with 5 industry appointed representatives and 4 public members is closer to 50-50 than most FAIR plans around the country. But we don't need to fight about the merits. But I'm surprised because we've heard quite a bit about how assessments impact costs for consumers, that we would assert here that public members don't have any interest in the public operation of this quasi-public entity any differently than industry appointed representatives. I think as the appointing entity for the public members, I know that the department is always looking at an application for a public member, people who have experience in the field, people who have the capacity and interest in overseeing the financial side of the FAIR plan's business operations. As a board member, they would have that fiduciary obligation. So I think we may want to tone that rhetoric down a little bit. But Mr. Chairman, I'll leave it at that.
Yeah, and if Mr. Rickwood, if you could give me a list of those states that have a majority of public members, I'd be curious because I'm not aware.
You're looking it up?
Yeah.
Oh, Senator Dames?
Well, thank you, Mr. Chair. And my question would be, I don't see how adding outside members to the FAIR plan is going to reduce the cost of insurance. Now, when I look at the recommendation number 2, it talks about expanding coverage options to offer a product to affordable housing providers. That's not going to drive down the cost of insurance. That's going to shift the cost of insurance. And I think too many times we look at different things that can get the cost of insurance down in certain areas and thinking that we've driven the cost of insurance down, which we haven't. We've just made a shift to a different group of consumers that are paying that. And so I think we want to be cautious, and I'm not sure, I'm not connecting the dots that show me how adding outside members to the FAIR plan is going to drive down the cost of insurance.
Yeah, I think by its very nature, the FAIR plan, to the extent that it's using, is doing exactly that. It's cross-subsidizing people who are having difficulty finding, getting insurance by those who are having an easier time getting insurance. So certainly would grant that there's a cross subsidy involved here, you know, by the very nature of the plan.
And I would certainly agree with you, Mr. Chair. I think that's absolutely true. I mean, that's the way the process works.
Yep.
But I think the task force was designed to figure out ways to bring down the cost of insurance, not to shift the cost of insurance. And I think here we're talking about, the way I would see this, we're looking at trying to get more of the cost shifted, not driving down the cost. And I think that's an issue.
Ms. Johnson?
Yeah, thank you, Chair and Senator Dames. I think the recommendation, you know, where I've been coming from is also the availability of insurance, and not having availability of just being able to get coverage within a reasonable amount of applications or time period. And I think that's also where Josh has been coming from too, with the common interest communities. And so if there are gaps in the market, then I do think that this is a way to help address that, with, you know, the goal of these, you know, properties, homeowners, moving back into the admitted insurance market.
Yeah, I would say that the reason I'm here as, you know, and as an author of the bill was that because I was getting tons of complaints from members of Homeowners Association that their Homeowners Association just couldn't get insurance at all, or if they could, it was at, you know, 4 times what they had paid the previous year. So that is a big reason why we're here. Jean?
Thank you, Mr. Chair. The second part of this, I just feel we've taken a jump from what we all agreed made sense, which was number one, a feasibility study on what are the facts here? What are the losses, the premiums? What kind of surplus reserves would we need to have in order for this to work appropriately? And now we've moved into number two that says, well, let's just move right into expanding and implementing without that detail. So in my mind, number one is the first step, as opposed to moving into that secondary part. And my concern on the makeup of the FAIR plan is the last thing we want to do is drive insurers out of the state. We're starting to come out of this problem, and we could move our way right back into it if we start assessing insurers. So it's a precarious cliff we're standing on there.
Okay, and Mr. Terman would like to address us on the question of what is our charter.
Yeah, I may have made a clerical error. I believe that the intent of this recommendation was just to be regarding the board composition. Yeah, so I noticed now that there's kind of a mincing of 1 and 2. I believe that was the intention of including on today's agenda.
Okay. Yeah, I think so. Do members have any specific suggestions about how they would like to see this tweaked? If not, then we can just go to the 5 to 5 on the language as written. So
Okay, so the 5 to 5 on the
yeah,
current language, Charlton's. Okay, so everybody think through, thumb back to your guide. Oh,
Mr. Chair, just,
Yeah, Mr. Rickwitty?
Mr. Chair, thank you. Just in light of Mr. Chairman's comment, are we looking at the language in full, or are we just sort of thinking of this as the board composition component of the current recommendation? Just before we get to the voting.
Well, let's see, we addressed the initial fair plan recommendations last time. So it's just, we're just voting on what's here on this right now. So we already, no?
Some of this.
Oh, okay, so I'm gonna let Mr. Terman take another stab at what he thinks that what we should have.
I think the fifth through Friday, it would be helpful if it was just the board composition. I believe that's what the intent was, and the other language would be kind of covered in the recommendation number 1.
So there should be a period where the first comma is basically, and then delete the rest. Is that clear?
So, and just to Peter's point, the legislature would need to update this statute. So I'm guessing the task force recommends the legislature consider updating the board composition of the Minnesota Fair Plan.
Okay, that's much simpler.
so members, based on that, please consider your rating. And for our online members, please drop that in the chat. Okay, I think everybody's in. Okay. Results are as follows. 3 votes of 0, 3 votes of 2, 1 rating of 3, and 4 ratings of 5. Oh, you were 1?
Receiver.
Okay, so 1 of 1.
Okay, we got one more left to go.
Okay, so draft recommendation number 7 pertaining to alternative dispute resolution statutes. Chair Elkins, any context for this one or any other members you wish to?
I think
Speak to it.
we're gonna let Mr. Brickwitty introduce this one. He's been working on this one.
Thank you, Mr. Chairman. This proposal comes, I think, in response to the testimony that we received from Beltrami County and have talked about a little bit subsequently. And I think really good conversation amongst task force members. There did seem to be some, I think, confusion about what the existing law provides for consumers in this place. And so I think, Mr. Chairman, you were gracious enough to help us get in contact with House Research to at least just get some draft language drafted up. I think we actually have maybe an edit or two still to go, but this at least lets members kind of get a sense of where we might be going. And I think from our perspective, consistency so that all parties in the ecosystem understand that we have the same appraisal process across all policy types is probably a good thing based on the confusion that we've heard. And that lack of consistency and clarity has, created perhaps an uneven experience for consumers and also for companies. So I think happy to answer any questions and kind of look at the language, but I think the intent is to clarify that 65A provides for up to 2 years from the date of loss for either party to move into the appraisal process. It's a lot of language and a long bill because it's like 6 pages or 4 pages of just getting to where the changes would be in 65A. But the substance is pretty simple.
Questions, comments? Jean?
Perhaps this is my error. Were we provided this in advance of this meeting? When
It was in the package, I think.
in package that was sent by Austin?
He just stepped away. But
Mr. Chairman, I think Austin posted it yesterday
Oh.
publicly.
Okay, it wasn't in his email of information at all. I didn't realize that it wasn't pointed out that it had been posted, or I would have gone to the postings for something new. I just feel I need some time I'd like to say I could read this in 2 minutes, but I can't.
Mr. Axfig?
Yeah, Mr. Chair, I would express the same sentiment. I, without being able to sit down and review and vet this, I'm not sure it would be responsible for me to weigh in. So I would be a no on this if it were to move forward today.
We
just
hold off
because-
on voting on this till next time?
Certainly, Mr. Chair. And again, I think we have a couple of technical edits on the draft as well too, but it seemed prudent to at least share it with members. I think, again, the concept is the one that Beltrami County has brought forward for the task force's consideration about clarifying what the amount of time either party has to move into the alternative dispute resolution process following the date of loss. And there's, Mr. Chairman, Gene, to your point, there's probably more than one way to get to that concept. This is just one for members to sort of think about. I think from our perspective, we felt like rather than trying to sort of reconcile 2 separate sections of statute, it would be cleaner to at least start with just writing it out in a new section of law, but you certainly could do a sort of a more page and line approach.
Yeah. So just, it looks like, so there's a big section of language being deleted and basically replaced.
Yes, Mr. Chairman, I think that that is the approach laid out in this draft. So striking, beginning on page 5 of the bill, striking the existing language that is in conflict between 65A01 and 65A.26. And then you see the corresponding change in 65A.26. And then writing a new section proposed as 65A.304 that repeats a lot of the stricken language, but clarifies the point that members will see on the screen. It's the concept behind the bill is that alternative dispute resolution or the appraisal process can be accessed by either party for up to 2 years from the date of loss for any claim stemming from any peril that's covered under the contract.
Mr. Chair, can I just ask a clarifying question, Peter? Would this also apply, these changes also apply to surplus lines or just the admitted market?
Mr. Chairman, I might need to defer to somebody who actually has a legal degree on that question, but I could follow up with our staff attorneys and come back next time.
Okay, so we're gonna pick this one up at the next meeting. So we're punting on 2 of them, or I'm sorry, Tim Johnson wanted to say something.
Oh, I did, but I think you just addressed it. I was just wondering if we were going to have discussion about it today or we were going to discuss it next session. That was all I was wondering.
No, and we're discussing it today, but we have a number of members, including me, to be honest, that have not looked at this closely enough to vote on it. So we're gonna postpone the vote until our final meeting. But if anybody has any comments who has had a chance to really study it and would like to make them today, that will help grease the skids.
Sure. I haven't had a chance to take a look at it because I didn't get that, but I can tell you the number of calls to my law firm about people that are outside of that 1 year timeframe to no fault of their own, and honestly, to sometimes no fault of the carrier, is absolutely staggering. So extending that to give people the time to resolve any disputed insurance claims is definitely favorable. I haven't looked at that language, but it would help a whole lot of people in Minnesota, and certainly the folks in Beltrami County. Thanks.
That would be my question. Does this address some of the concerns that Beltrami County was expressing? Yeah.
This would not apply retroactively, though.
Mr. Chairman, this draft would not apply retroactively, no.
So this wouldn't help the people of Beltrami County in their specific
But it would,
incident.
it would help in future examples
Well.
of that case.
We can debate that.
This is going to happen again. Yeah. Okay, so, do we have any other business to conduct today then? I don't think we do. Yeah, so the next meeting, is, February 5th, so we've, carrying two of these over, the last two. And then we'll review and, adopt the final report. Trying to think of anybody else can think of for the good of the order right now. Not seeing, yeah.
Mr. Chair,
Yeah,
if there are changes, especially to the recommendations, could you make those and send those around to the committee members as soon as possible so that we can all just, have that in advance, at least maybe a few days in advance of our next and
I'm
final
gonna try
meeting?
and get the one on the tort reform done tonight because I'm getting on an airplane in the morning.
Yeah, and I think any other additional documents in advance, further in advance would be helpful as well, just for all of us for consideration. And just wanted to clarify, so we're going to be doing the fist to 5 on 2 recommendations before we vote on the final.
Yep.
And the goal next meeting is to vote on final potential recommendations. And does that require
Nice
consensus, or does that require majority?
I'm sorry, does it require?
I just wanted to clarify if it just requires a majority vote in order to have the task force recommend something, or if it's like, I just wanted to clarify that.
Good question. Do you know the answer to that? Justin?
Yeah, LCC practices that it would be a majority to be included in the report. Yeah.
Thank you.
And I'll speak briefly to the report and things. I'll make these edits and I'll share these with the working group members, hopefully by early next week. I'd like to also send out another version of the draft report that will hopefully be the parts of the report that would not include the recommendations. So you'd be able to see the report, and then with the recommendations that are adopted, those would be placed into what I'll send out hopefully by the end of day on Friday. I'll ask for edits for that language to be returned to me by the 30th of January, so I can make them and so that we can have it at the next meeting.
One other question, I guess, just because I'm not sure if all the task force members are actually present, either online or in person. Can you just make sure that everyone's aware that we will be voting on final recommendations at the next task force meeting?
Yeah, I think that's been the plan from the beginning. Yeah, yeah. Yeah. I don't know, I'm fading fast. You can probably tell. This is my third one of these today. Okay, well, if there's no other business before us, then I will call this meeting adjourned. Thanks. Oh.